Good morning. My name is Sarah Gelgor, and I'm the chair of the Compliance Audit Committee. I'm joined today by my fellow committee members, Lawrence D'Souza and Ramin Farauji. The committee administrator has confirmed that we have quorum, so I will call meeting 2 of the Compliance Audit Committee to order. Welcome, everyone. Today's meeting is being held with committee members, city staff, and parties participating both by video conference and in person at City Hall in Committee Room 1. City Hall is open to the public and anyone is welcome to attend the meeting at City Hall today. The public may continue to participate electronically by video conference. This meeting is also being live streamed online at www.youtube.com/Toronto City Council Live. I ask everyone for their patience with any delays or technical issues. I'd like to ask everyone to please keep your microphones on mute unless you are speaking. Members, please ensure that your video is turned on at all times. As part of each agenda item, I'll ask members to raise their hand or unmute their mic if they wish to ask questions or to speak. When voting, members, please raise your hand in front of your camera to indicate your vote. Although we are in different locations and meeting remotely today, the Compliance Audit Committee acknowledges the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Members, are there any declarations of interest under the Municipal Conflict of Interest Act? If you have an interest, please raise your hand or unmute your mic to let me know. Okay. May I have a motion to confirm the minutes of the meeting on May 10th, 2023. I'm looking to my members. Okay, thank you, Member D'Souza, and it's seconded. Okay. Sorry. Oh, all those in favor, please raise your hand. Thank you. And everyone's in favor. No one is opposed. The motion carries. I'll now outline the procedure and the format of the committee meeting. We have 5 items on the agenda, which are 5 compliance audit applications. Before we consider the applications, I'll outline the procedure and format for considering them. The 5 applications considered today are as follows. Item EA 2.1, compliance audit application by Kevin Wiener for election campaign finances of Grant Gonzalez. Item EA 2.2, compliance audit application by Kevin Wiener for the election campaign finances of Peter Hanges. Item EA 2.3, compliance audit application by Kevin Wiener for the election campaign finances of Frank Mara. Item EA 2.4, compliance audit application by Kevin Wiener for the election campaign finances of Vivian Parker, and item EA 2.5, compliance audit application by Kevin Wiener for the election campaign finances of Keisha Ross. An applicant, candidate, or their agent who has registered with the clerk may speak to these items. The applicant and candidate will be given sufficient time to address the application. For each application, we will hear from speakers in this order. 1, the applicant or their agent, and 2, the candidate or their agent. If you wish to speak and have not already registered your intention to do so, please email the clerk's staff now at complianceaudit, that's one word, @toronto.ca. Speakers are asked to confine their comments to the compliance audit application item being considered. After each speaker, Compliance Audit Committee members will have an opportunity to ask the speakers questions. Members may ask questions of city officials to obtain information relating to the matter under discussion. If the committee decides it needs to meet in closed session to deliberate in private, I will move a motion to close the meeting, at which point members of the public and media, if present, will be moved into the WebEx lobby and readmitted once the committee resumes in public session. We may do this multiple times this meeting, as we will consider each application separately. For each item, after we have completed our closed session deliberation, we will resume in public, and the committee will make its decision at that time. So we're going to move now to preliminary motions. Are there any preliminary motions from members? All right, hearing none, let's proceed with our first application. EA 2.1, compliance audit application by Kevin Weiner for the election campaign finances of Grant Gonzalez. Before we proceed with this application, we have a preliminary matter to consider. A communication has been received from the applicant, Kevin Weiner, to withdraw his application for compliance audit for candidate Grant Gonzalez. I'd like to begin by inviting the applicant or their agent to make a brief statement regarding the request for withdrawing the application for compliance audit for candidate Grant Gonzalez. I'll then invite the candidate or their agent to respond to this request. The committee members may ask questions of the applicant or their agent, as well as the candidate or their agent following their remarks. Is the applicant, Kevin Weiner, or agent present?
Yes, I am, Madam Chair.
Thank you. Please proceed with your remarks.
All right, thank you, Madam Chair, and through you, members of the committee. My name is Kevin Weiner. I'm the applicant for this application, and the remainder of the applications the committee will be hearing today and next week. As the committee is aware, this is an imperfect process, the compliance audit process. In the absence of members of the public filing complaints, there is no real oversight of election finances or process to ensure that there's compliance. When the complaints are made, it's generally made on the very limited information available in public filings, and you have to determine whether or not there's reasonable grounds to believe there may be a violation of the Act. In this case, when I filed my complaint, I believed, based on the filings and the very large deficit that had been carried forward, that there were reasonable grounds to believe that some of that deficit or all of it had been financed personally by the candidate. And I appreciate that anytime there's a complaint made, it puts stress and uses up the time of the candidate, which is why I wanted to keep this short and withdraw the application. Mr. Gonzalez did file a response, including an invoice, which made clear that at least the $20,000 of that deficit came from an invoice that did indeed genuinely remain unpaid through the end of the original campaign period, which means, in my view, there's no longer reasonable grounds for me to believe that this deficit was financed by the candidate from personal funds rather than representing a genuine deficit, which was carried through to the extended period. So given I no longer have reasonable grounds to believe there's a violation of the Act, I don't wish to waste Mr. Gonzalez's time or the committee's time through pursuing this application. I'd request that my application be given leave to be withdrawn.
Thank you. Compliance Audit Committee members, do either of you have any questions for Kevin Weiner on this request?
I don't.
No. Okay, thank you. And is the candidate, Grant Gonzalez, present?
I am present.
Do you wish to make any comments?
Sure, just very briefly, thank you to the applicant, Mr. Weiner, for considering withdrawing the application. I'm still more than happy to respond for the committee, but I definitely won't disagree with a withdrawal as well. And of course, just to reiterate that members of the public will continue to have an opportunity to scrutinize my financial statements because I have extended my campaign period. I'm required to file a supplementary audit and audit report. So there will be other opportunities if there are further questions, but with that said, I'll pass the mic back to you, Chair.
Thank you very much. Members of the Compliance Audit Committee, do you have any questions?
No, someone.
Okay.
No, I don't.
Seeing none, I now have a motion to go into closed session, and okay. This is the reference to technology that I made in my opening remarks. You could bear with us for one moment, please. All right, and the reference reads as follows, that the Compliance Audit Committee recess its public session to meet in closed session to consider item EA 2.1, compliance audit application by Kevin Weiner for the election campaign finances of Grant Gonzalez to deliberate in private. All those in favor? Thank you. And the motion carries. All right, I'll ask the clerk to temporarily close the meeting to members of the public and to only provide access to members and appropriate staff for the closed session portion of this meeting. In addition, the YouTube live stream will be suspended until the closed session is over. Members, I would also remind you to arrange your surroundings so that no other person observes any part of the closed session discussion.
Hello, everyone. This is the committee administrator from the city clerk's office. I'm just going to read a statement for those that are connected remotely via WebEx. The committee is now going to move into closed session. We will first suspend the live portion of the WebEx live stream. We will then place anyone that is not needed for the closed session into a video conference waiting room. You will not be able to see or hear the video conference until the committee resumes in open session. Please do not disconnect or leave the WebEx meeting. You will be automatically readmitted to the video conference once the committee resumes in open session. If you become disconnected from the WebEx meeting while in the waiting room, please reconnect using the same meeting connection details that were provided to you earlier, or you can email the city clerk's office at complianceaudit@toronto.ca, and we will work with you to reestablish your connection. The WebEx recording has been suspended. We are now moving individuals into the waiting room. And just a reminder to anyone in the committee room at City Hall who is not needed for the closed session to please exit the room. Members, please do not begin any discussion until we advise you. Thank you.
Thank you, everybody. We have completed our closed session deliberations, and I understand that we do have a motion, and I'm going to turn it over to Member D'Souza to read the motion. It will be on the screen.
Madam Chair, do you want me to read it?
I believe so. I'm looking at Madam Clerk. I think that makes sense. The guidance is yes.
The Compliance Audit Committee, the motion is that the Compliance Audit Committee grant the applicant's request to withdraw the compliance audit application of Kevin Weiner for a compliance audit of the election campaign finances of the respondent, Grant Gonzalez, for the following reasons. The Compliance Audit Committee held a hearing on July 13th to hear item EA 2.1, the application of Kevin Weiner for a compliance audit of the election campaign finances of the respondent, Grant Gonzalez. At the start of the hearing, the applicant made a request to withdraw the application. The committee considered section 88.331, subsection 1 of the Municipal Elections Act 1996, which states, an elector who is entitled to vote in an election and believes on reasonable grounds that a candidate has contravened a provision of this act relating to election campaign finances may apply for a compliance audit of the, can we scroll it up, please? Can we, yeah. The committee considered, okay, while these are unusual circumstances, the committee determined that the applicant's request to withdraw may be permitted as withdrawal request indicates reasonable grounds for the application may longer exist. Additionally, section 4.6 subsection 1 of the Statutory Powers Procedure Act enables the committee to dismiss a proceeding without a hearing if it is frivolous, vexatious, or is commenced in bad faith. The committee decided that given the applicant's request to withdraw the application, it would be frivolous to proceed. While the committee did not hold a hearing to assess the merits of this matter, these reasons could support a decision to reject the application in accordance with section 88.33 subsection 7. The respondent did not object to the applicant's request to withdraw the application.
All right. Can we take a vote, please? All those in favor? And no one opposed. The motion carries. Thank you. All right, at this time, I'd like to move to item EA 2.2. So, item EA 2.2 is compliance audit application by Kevin Weiner for the election campaign finances of Peter Hangis. Are there any preliminary requests from the parties? All right, seeing none, the applicant and the candidate will now be given the opportunity to speak. They will each be given sufficient time to address the application. Please confine your remarks to the compliance audit application before us. I'm going to turn it over to Kevin Weiner, and you may begin your presentation.
Thank you again, Madam Chair. Peter Hangis was a candidate for mayor in last year's election. Just to provide some background for the committee, given I filed a number of applications, I don't really know any of these candidates. There's no animus here. Basically, my process here was I reviewed the filings that were in the city's website for particularly large deficits, candidates who indicated they had no income and ran a deficit, and candidates who did not file financial statements, but there was some evidence to indicate that they did incur expenses and or raise revenue. And I filed applications, again, because there is no process to have anyone look at whether there's a violation of the Act in the absence of the application process and bringing it formally to this committee. So with respect to Mr. Hangis, Mr. Hangis did file a financial statement. What I would note, first of all, is that while Mr. Hangis ran a deficit, he did not seek an extension of his campaign to fund that deficit through an extended campaign period, as Mr. Gonzalez did. And I can just share, I cannot share. I can indicate there is a list on the city's website of municipal election campaign extensions, and that list does not include Mr. Hangis' name as a candidate who sought a campaign extension. With respect to the financial statement, I didn't submit the financial statement with my application. I assume, Madam Chair, the members of the committee have access to the financial statement, but if not, if the IT can set it up, I can share the financial statement from my screen. Madam Chair.
I apologize. We're just checking the technological capabilities and whether we are able to do that. I do have a copy of the financial statement in front of me. Give us a moment, please. All right. Yes, you are able to share your materials at this time.
So, all right. So I have here the financial statement auditor's report for candidate Peter Hangis, and the committee will see as I scroll down to the box C, statement of campaign income and expenses. First, that the amount borrowed for the campaign was $0. The total campaign income was $0. And then under expenses, we see about $3,000 in advertising, about $1,000 for brochures and flyers, $490 for phone and internet expenses, $200 for salaries, benefits, honoraria, $400 for buttons, $354 for keychains, and total expenses subject to the spending limit, $5,300. Total expenses, $53, $59, $52. And so the test before the committee, essentially there's a twofold test. The first is whether the committee has reasonable grounds to believe that there's a violation of the Municipal Election Act. And then secondly, even if the committee believes there are reasonable grounds, the committee can still decline to order an audit under some previous jurisprudence from the OCJ, Superior Court, and Court of Appeal. When the City Council is responsible for this, it was held that once reasonable grounds to believe are established, it's automatic to order an audit. Since then, there's been some additional jurisprudence from the Superior Court that still recognizes some jurisdiction from the committee. I apologize for that. Let me just silence my phone. Some jurisdiction from the committee not to order an audit, although those were circumstances where the candidate appeared, it was clear an audit would reveal nothing, that it was just an inadvertent error, and it made no sense to order an audit. My submission would be, in the absence of those exceptional circumstances, once reasonable grounds to believe a violation has occurred is established, that a compliance audit should follow. And it's important to contextualize, just because a compliance audit is ordered, it doesn't mean that charges will be laid. A compliance audit is a process to gather more information, to allow the committee to exercise a reasonable and informed choice about whether or not to commence legal action. And secondly, reasonable grounds to believe doesn't mean that the committee needs to believe that there was probably a violation. There just needs to be reasonable and credible evidence, which is not based on speculation or conjecture, that can lead the committee to the conclusion that a violation may have occurred. And the courts have referred to this as akin to a search warrant process, which happens sort of at the beginning of potentially inquiring into charges to gather that additional information. So in this case, my application is that there are two potential grounds for a violation. One, that the financial statement is not accurate, which is an offense under the Municipal Elections Act that carries a mandatory penalty, among other things, of being barred from office until the next election unless the court finds that it was committed inadvertently or through a good faith mistake. And secondly, the failure to open a campaign account before incurring expenses or raising money. Now, in this case, no money was raised. We do have a deficit. And of course, the Act contemplates that deficits can occur, but generally the Act contemplates that those deficits will occur when the campaign period is being extended until those debts can be paid off. And there are a couple of basically legal ways a candidate can maintain a debt. One is by taking out a loan, and that's regulated by Section 88.17 of the Municipal Elections Act, which states that a candidate and his or her spouse may obtain a loan only from a bank or otherwise recognized lending institution in Ontario to be paid directly into the candidate's campaign account, and it can only be guaranteed by the candidate and his or her spouse. Secondly, as we saw in Mr. Gonzalez's case, there may be expenses that have been incurred but not actually paid for during the campaign period, and then the campaign period being extended to raise money into the campaign account and then actually pay those expenses. The Act does not require that funds be received before expenses are incurred. What it does require is that all campaign expenses be paid directly from the campaign account. Under Section 88.2 of the Municipal Elections Act, paragraph A states no contributions, a candidate shall ensure that no contributions of money are accepted or expenses are incurred unless one or more campaign accounts are first opened at a financial institution exclusively for the purposes of the election campaign. B, all contributions of money are deposited into the campaign account. C, all funds in the campaign accounts are used exclusively for the purposes of the election campaign. And D, all payments for expenses are made from the campaign account. So what the Act doesn't allow is for a candidate to simply a candidate can self-finance a campaign, but a candidate can't self-finance a campaign by simply paying for everything from their personal account and then saying my campaign's in deficit and allowing the public to infer that they simply self-funded it. Certain things, in certain circumstances, a candidate can make a donation of goods and services to their campaign. If they have, for example, signs from a previous campaign, they can give that inventory to their campaign. There's no transaction into the campaign account, but there is an in-kind contribution and a corresponding in-kind expense to cover that. And that's not the case here. There is no statement of there being an in-kind contribution from the candidate, which has a special line item in the financial statement, specifically in Schedule 1, summary of contributions. It asks if there are contributions in money or in goods and services from the candidate and spouse. In this case, both those boxes are listed at 0. So if the campaign expenses are paid by money, that can be self-financed, but there is a process. The candidate needs to open a campaign account, the candidate needs to deposit money into that campaign account, and then the candidate needs to extend the money out of the campaign account. And the requirement for a campaign account is important because it ensures that there does need to be an audit. There is an appropriate trail of funds into and out of a single account that relates exclusively to the campaign. So what we see in this case is not only is there a deficit, there was no extension to file a deficit. Basically, the campaign just ended in the deficit. We do not know how these expenses were paid for, given no money has ever gone into this campaign account. And to the extent there were unpaid invoices, there was no extension to pay those invoices. It just ended. And to the extent they are paid after the campaign period, the committee can infer they must have been paid for by the candidate from his personal funds, which would be a violation of the Municipal Elections Act. Moreover, the fact that there is absolutely 0 in contributions listed in my submission leads to a reasonable inference that there are reasonable grounds to believe that no campaign account was even opened. Now, obviously, you need to open a campaign account to take contributions into that account so that you can spend money. But even if all you're doing is just using property the candidate owns and it's entirely funded through in-kind contributions and no actual money is changing hands to or from anyone, The Municipal Elections Act is clear. Again, 88.2(1)(a), no contributions of money are accepted or expenses are incurred, not just expenses of money, just any expenses are incurred unless one or more campaign accounts are first opened. So even if you want to have a purely in-kind based campaign, you still need to open that campaign account and have it exist in order to incur those expenses. And finally, the other grounds on which the committee can infer that no campaign account was ever opened is that under expenses, the expense for bank charges incurred until voting day, as well as the expense for bank charges incurred after voting day, is $0. And given that banks basically treat campaign accounts as business accounts and therefore charge money for those accounts, in my submission, if there had been any campaign account opened, there would be some indication of an expense for bank charges. So my total submission to the committee is that there are reasonable grounds to believe that these expenses that were incurred have in fact been paid for by the candidate, that they have been incurred notwithstanding the fact that no campaign account was ever opened. And therefore, there are reasonable grounds to believe that there are at least 2 violations of the Municipal Elections Act. Now, that doesn't mean the committee needs to lay charges, but in my view, it does raise sufficient questions that this isn't one of the situations where a committee has nonetheless chosen not to proceed with a compliance audit because the candidate came forward, explained the situation, it was a good faith error, and a compliance audit would accomplish nothing. In this case, we don't actually know how these expenses were paid for. Did the candidate pay for them by credit card and then pay them from personal funds? Did they decide not to pay these invoices? Did they get suppliers to write them off? In which case, if depending on the size of that write-off, it could be an illegal contribution. We don't have that information because, again, the financial statement does not demonstrate a campaign that was in compliance with the Act, where funds came into the account and then were paid out of the account. It just indicates these expenses were incurred, and how they were paid remains a mystery. So under these circumstances, my submission is that there are reasonable grounds to believe that there has been a violation of the Act, and this is not one of those rare circumstances where the committee should basically let that violation slide at this very early juncture without even having a compliance auditor look into how these expenses were in fact paid for. After a compliance audit, once the committee has more information, it may well be that charges are not warranted, but in my view, it would be inappropriate to not conduct an inquiry into this campaign at this very early juncture. Subject to any questions the committee may have, those are my submissions, Madam Chair.
Thank you very much, Mr. Wiener. Very thorough submission. Members of the Compliance Audit Committee, do you have any questions for Mr. Wiener?
No, I don't have any questions.
No. Okay. Do we have Peter Hanges or his agent here? And if so, could either of them come forward, please? Okay, I have no indication that Mr. Hanges or his representative is here. So with that, I am going to propose that the committee go into closed session, and I'm going to ask for the motion to be displayed on the screen, please, by city staff. Okay, just bear with us for one moment, please. All right, and so the motion reads as follows, that the Compliance Audit Committee recess its public session to meet in closed session to consider item EA 2.2, compliance audit application by Kevin Weiner for the election campaign finances of Peter Hanges to deliberate in private. All those in favor? Okay, thank you. The motion carries. And I will ask the clerk to temporarily close the meeting to members of the public and to only provide access to members and appropriate staff for the closed session portion of this meeting. In addition, the YouTube live stream will be suspended until the closed session is over. Members, I would remind you to arrange your surroundings so that no other person observes any part of the closed session. All right, if you could just give us a few moments, please.
Thank you, Madam Chair. Hello, everyone. This is the committee administrator from the City Clerk's office. I'm going to read a statement for those that are connected remotely via WebEx. The committee is now going to move into closed session. We will first suspend the live portion of the WebEx live stream. We will then place anyone that is not needed for the closed session into a video conference waiting room. You will not be able to see or hear the video conference until the committee resumes in open session. Please do not disconnect or leave the WebEx meeting. You will be automatically readmitted to the video conference once the committee resumes in open session. If you become disconnected from the WebEx meeting while in the waiting room, please reconnect using the same meeting connection details that were provided to you earlier, or you can email the City Clerk's office at complianceaudit@toronto.ca, and we will work with you to reestablish your connection. The WebEx recording has been suspended. We are now moving individuals into the waiting room. And just a reminder to anyone in the committee room at City Hall who is not needed for the closed session to please exit the room. Members, please do not begin any discussion until we advise you. Thank you.
All right, thank you, everybody, for your indulgence. We have completed our closed session deliberations, and I will now share the decision. We will be posting that. So the motion is that the Compliance Audit Committee rejects the application for compliance audit of the election campaign finances of Peter Hangis. I will not read through the decision in full. The reasons for the decision will be posted and will be shared with the applicant as well as with the candidate. Do any members wish to speak to the decision? All right, seeing none, I'd like to vote on this, and can you please, all those in favor, please raise your hand. Okay, and none opposed, and the motion carries. Thank you. Okay, before we move to our next item, what I would ask, actually, I guess I will first open the next item, and then I'll make my request. So our next item is item EA 2.3, Compliance Audit Application by Kevin Weiner for the election campaign finances of Frank Mara. And I would ask, while it's certainly the role and the objective of the committee to provide, as much reasonable opportunity for the parties to make submissions as possible, just in the interest of expediency, if we could ask the parties to perhaps focus on relevant, pertinent information. There may be some repetitive background information for more than one application, and so if we could try to limit our submissions to around 5 minutes, the committee would be grateful. With that, I wish to give the applicant and the candidate the opportunity to speak. And as just noted, they will be given sufficient time to address the application. Please confine your remarks to the compliance audit application before us. And would Kevin Weiner or his agent please come forward?
Thank you, Madam Chair. I was wondering if it might be possible to have a copy of the decision in a minute or two to review it before making my submissions. Many of these applications with respect to deficits raise the same issues, and it would be much easier for me to confine my remarks to the matters most relevant to the committee's consideration if I know what was determinative for the last application.
Understood. That's reasonable. Give us a moment, and we'll see how we might get that to you. The motion has now been posted live on our website. Are you able to access that?
Yes, I see it, Madam Chair. If I can just have a minute to read through it. All right, thank you, Madam Chair. I've had a chance to read through it. This application is with respect to Frank Mara, who is a candidate for Mayor of Toronto, and I believe is present today. So this application raises very similar issues to the previous application. I'll direct the board, the committee rather, to the financial statement. As with the last financial statement, no revenues were claimed. Expenses were claimed. There's no indication that any funds were expended on bank fees. I would like to correct one thing I said in my last submissions. I did say the campaign account needs to be opened even if the only expenses are goods and services. That was actually a mistake on my part. The Act does exempt in-kind donations as an expense that requires the opening of a campaign bank account before that happens. Although I'd submit that that can't be used as a way to circumvent the need to run funds through a campaign account. It's one thing if a candidate has goods and services that they already own and wish to provide to a campaign, but a candidate can't simply pay for a bunch of goods and services out of their own personal account and then donate those goods and services to the campaign. That those would be, in fact, expenses of money which need to come out of the campaign account. So my submission is, as with the last request, there's sufficient evidence in the financial statement to determine that there is reasonable grounds to believe that this financial statement is not accurate, and that these expenses must have been paid by someone, presumably by the candidate, although we don't know exactly how they were paid for, but the appropriate way to do that is to put money into the campaign account and pay it out. With respect to the question of materiality, I realize that this is not a case where you have likely overspending of the limit or over contributions. Have the candidate simply taken all of those expenses and simply put that amount of money into his campaign account and then paid all those expenses out and then ensured that that was accurately reported on his financial statement, there would be no issue. And certainly one of the issues with the financial statement appears to be an inadvertent error. Specifically, while $1,500 in signs were declared as a campaign expense, they were not correspondingly declared as a campaign contribution. And I'd agree for that. That's sort of a de minimis thing where, clearly it was an accidental mistake when filling out the form. It's not worthwhile to potentially have a prosecution over that. Nonetheless, I do think that while a compliance audit may not provide a ton more information than what's evident from the financial statement in terms of whether a campaign account was opened and how these expenses were paid for one thing, it would provide confirmation as to who actually did pay these expenses. Were they paid from the candidate's funds, or were they paid by anyone else, or were they written off by vendors? In my view, the audit committee can't simply infer that this was paid for by the candidate when there is no actual statement in the financial statement that this was paid for by the candidate and just not run through the campaign account. So that is information that would be helpful to the committee. Secondly, the legislation requires a compliance audit before any form of enforcement action can be taken by the city. Even if it's not going to shed much light, it has to happen. And by not ordering a compliance audit, the committee is essentially determining right now, before it has the information, that no prosecution is warranted. And in my submission, it's important to keep in mind that these are regulatory offenses. It's not, other than corrupt practices, it's not a quasi-criminal style offense that carries the stigma of doing something corrupt, where it's only in the most serious circumstances that enforcement should be taken. Provincial offenses are laid all the time for relatively minor things. You can be doing 10 kilometers over the speed limit and get a ticket, and that's a provincial offense, and you're in court and there's some enforcement action. And in my submission, it is important that there be some understanding that there's a need to comply with the Act, and if not, you can be subject to a certain degree of enforcement. If mistakes are made in good faith, there's provisions for relief there. You can have plea negotiations, things like that. But if none of this ever leads to any enforcement action other than the most severe corrupt offenses, then in my submission, the message it sends to candidates and the public at large is that there's no need to be diligent with campaign filings and with complying with financial law, because unless you do something very, very serious, there won't be any real enforcement. Even if it's the type of enforcement that leads to a $100 fine or something like that, where it's not a serious fine, some level of enforcement is, in my submission, appropriate. And again, this just starts that process. The committee still has the ability to receive the compliance audit report and have the full circumstances of exactly what happened with that campaign before deciding whether to make an enforcement decision. But in my view, it's not appropriate to exercise the discretion not to order a compliance audit when there's likely a violation and where it's not, at least we don't have the evidence right now that it was totally just a good faith accidental slip or omission that, the committee can sort of let slide at this point in the process. But I mean, Mr. Mara is here, and it may be that he's able to shed clarity, and that with that clarity, the committee may not wish to proceed. At the end of the day, my main goal here is just to ensure that there's an organ of the city taking a look at campaigns where there are potential issues.
Thank you, Mr. Weiner. I appreciate your submissions. Do any of the committee members have any questions at this time for Mr. Weiner? Okay, it looks like we do have Frank Mara here. Do you wish to proceed with your presentation?
Yes, thank you. Good morning, Madam Chair and committee members. First, I'd like to thank Mr. Weiner for doing a civic duty by presenting his concerns in these various filings that he's believes at least have some basis for further investigation or action. From my perspective, one of his issues is the maintenance of a campaign count. Other than providing you some direct evidence today, which I have, I just wanted noted that the financial statement doesn't otherwise provide for that capability, so that these sorts of concerns or issues are sort of allayed up front, which would be quite helpful, I think. As to his other concern regarding the inaccuracy of my financial statement, by failing to indicate my contribution, he may in fact be correct in that regard. I'll have to review it. I have not done so to this point. And if permitted, I would like to amend to correct that, because it in fact, all contributions were my own. As to the evidence of the campaign account, I do have two pieces I would like to share if I'm given that possibility here, so you can view it. And with your permission, I'd like to do so.
Please proceed.
Okay, how would I do so? I have two documents here. They're PDF copies of some banking information that establishes the campaign account.
So you probably want to share one.
Opening and closing.
You may want to share one at a time, and on your screen, I presume that there is the ability to share across the bottom. I believe we're using WebEx, and sadly, I'm very familiar with WebEx.
I see a share content tab or button. Is that the one I would make use of here? I'm afraid I'm not that familiar with WebEx myself.
If you hover over the share content.
So if you hover over it, you would click on the share content, and then you should get a screen up, and you'll have different windows, and you'd click on the window where the document is that you wish to share. It's usually the one in the top left corner.
It's a PDF document, so I'm looking for the app here. Let's see, where are we here?
So you'd want to open your document first so that you have
currently open.
Okay. And then once you're in WebEx,
open, yes.
You click on share. You should see a number of boxes come up that would have anything else that you have open, and you would share with the committee and attendees the document that you're referring to.
Let's try the Windows Explorer button here, I'm afraid. Okay. Sorry, that is not working for me. I'm not seeing where it pulls up. I can see the document, but I'm not finding the connection between those two. I'm sorry. Again, I'm not that familiar with this ability here, or facility rather. Share content.
Mr. Mara, this is Amanda Wald, the committee administrator. The chair has just asked that I try to assist. I think the instructions she provided
Sure.
were pretty on point. I know from our perspective, we can see a black screen where it says that you are starting to share content, but for some reason, we're not seeing the actual document itself. I'm not sure if you want to try canceling and maybe trying one more time to see if we have any better luck.
Okay, I'll attempt that. Uh-oh, where are we here? Okay, here's the share button. Content. Okay, there we go. Adobe finally appeared. Okay, here we go. Okay, can you see that?
Yes, we can. Thank you very much.
Okay, sorry for the delay. So this is a document I received on the account opening from my bank. That includes a copy of the convenience card there and the account header name, which is Frank Mara Campaign. The second piece would be showing the closing of the account, if that's of further use.
Mr. Mara, I just want to caution you that this is a public session and the public session is viewable on YouTube. Given potential, privacy concerns, I would suggest that you perhaps take it down.
I'm not as concerned for the financial aspect or my address because that's already public filing. The account has been closed with the end of
that's
my
fair.
campaign, so there's no risk there.
Okay.
Thank you, though, for that. And may I proceed to share the second document?
Yes, please.
Thank you. Guess I have to switch my view initially. Okay, there we go. I see how it works now. Okay. This relates to the same account. This is what they call an account close authorization. Date indicated there is October 31st, 2022. And again, it's in the name of Frank Mara Campaign. And that's just indicating that the account has been closed. Again, as to the financial statement, there may be, in fact, an error. Again, with the committee's permission or with your direction, I could proceed to look into amending that filing if it's permissible, to show my contributions were in fact entirely to cover the expenses indicated, including the in-kind contribution that I had for some election signs from a previous campaign. That would be the totality of my submission today. Thank you.
Okay, thank you very much. Compliance Audit Committee members, do you have any questions for Mr. Mara? And Mr. Mara, you can stop sharing your screen.
Okay, how do I close that?
I have one question for Mr. Mara.
Yes?
I believe this is not your first election as a candidate. Right?
That's correct.
Okay, thank you.
That's where the in-kind contributions of signage comes into it. Those were from the previous campaign.
So you're familiar with the rules and requirements of
I thought I was familiar enough for the purpose, but it looks like I may have omitted, again, showing those contributions to cover the expenses incurred, if that is the case with my financial statement.
Thank you.
Are there any further questions of Mr. Mara? All right, thank you both for your submissions. At this point, I wish to make a motion to go into closed session. And I'm just going to give the clerk a moment to, oh, all right. Can we vote on the motion, please? All in favor? Thank you. All right, the motion carries.
Thank you, Madam Chair. Hello, everyone. This is the committee. conference waiting room. You will not be able to see or hear the video conference until the committee resumes in open session. Please do not disconnect or leave the WebEx meeting. You will be automatically readmitted to the video conference once the committee resumes in open session. If you become disconnected from the WebEx meeting while in the waiting room, please reconnect using the same meeting connection details that were provided to you earlier, or you can email the City Clerk's office at complianceaudit@toronto.ca, and we will work with you to reestablish your connection. The WebEx recording has been suspended. We are now moving individuals into the waiting room. And just a reminder to anyone in Committee Room 1 at City Hall who is not needed for the closed session to please exit the room. Members, please do not begin any discussion until we advise you. Thank you.
Okay, welcome back. Thank you, everybody, for your patience. We have completed our closed session deliberations. At this time, I'm looking to my fellow committee members for a mover for the motion. The mover will just read the first portion of the decision. Ramin, thank you. All right.
The Compliance Audit Committee rejects the application for a compliance audit of the election campaign finances of Frank Mora. Madam Chair, should I read the reasons, or the reasons are stated as below?
No, there's no need to read the full motion, and it will be posted. The reasons will be posted. Now, do any members wish to speak to the motion? It's not a requirement. Okay, so with that, can we have a vote, please? All those in favor, raise your hand. Thank you, and the motion carries. And the motion will be posted on the city website very shortly, or sorry, the decision rather. All right, at this time, we're going to move to our next item, item EA 2.4. That is the compliance audit application by Kevin Weiner for the election campaign finances of Vivian Parker. Are there any preliminary requests from the parties? All right, seeing none, I'm going to proceed. The applicant and the candidate will now be given the opportunity to speak. They will each be given sufficient time to address the application, and I would ask that you please confine your remarks to the compliance audit application before us. Mr. Weiner, you're welcome to speak to your submissions.
Thank you, Madam Chair. So this compliance audit is different from the previous ones in that it does not relate to a deficit, but to a failure to file any financial statement whatsoever. The committee can confirm that on the city's website, Mr. Parker is listed as someone who is in default of the Municipal Elections Act requirements to file a statement, which means he did not file a statement either by the deadline or within the 30-day grace period where you can file and pay a $500 late filing fee. And in fact, even if you do file and don't pay the late filing fee, the city will still post your financial statement. You'll just be deemed in default and still barred from running. So what I'd say off the bat is it's not really in question whether there are reasonable grounds to believe that there is a violation of the Municipal Elections Act. There very clearly has been, in that no financial statement has been filed, and the filing of a financial statement is mandatory. So the real question before the committee is whether or not, in light of that fact, to initiate a compliance audit. Now, I recognize that where there's a failure to file a financial statement, there's certain automatic penalties, namely forfeiture of any office to which a candidate has been elected, which doesn't apply here, and a bar from running for any municipal office until after the next election in 2026. And that is supposed to serve generally as a sort of automatic deterrent, because most candidates want the ability to run again, although for some candidates, they may not be deterred by being barred for one further election if they're a candidate who's not likely to achieve office regardless. Many more candidates did not file financial statements than the number of applications I've made. Where I have made an application, it's because I conducted some relatively quick research, and that research indicated that it's not just the candidate who sort of ran on paper, didn't do anything, and then just failed to file the form with a little checkbox that says I didn't incur any expenses or raise any revenues. All of these complaints, including this one, there's some evidence to indicate that the candidate in fact did raise money and or incur expenses, which means the failure to file a financial statement has deprived the public of knowledge of what actually happened in that campaign. So even though the committee's come to the conclusion in the previous applications that a compliance audit would not shed more light. In my submission, this is a situation where a compliance audit does shed light because, simply put, we have no idea what has happened in these campaigns in the absence of someone taking a look at the actual expenditures and revenues and providing a report to this committee, which would be publicly available, as to what has been raised and what has been spent. So in this case, the evidence provided attached to my application is a GoFundMe for Mr. Parker, which indicates $1,111 raised, and some of those contributions are visible, and it can be seen. Some of them are listed as anonymous, and in fact, on that website. And if I can just have the ability to share my screen, Madam Chair.
Yes, go ahead.
Go. So this is the actual website, the GoFundMe. And if I open up the see all of donations, and it was my mistake in the application. I said there were numerous of 100 or more, $100 donations. The donor doesn't need to be publicly disclosed, but you can see there's a 151 here. We have a name, but we don't have the address information that would be on a public statement. So there is one donation, at least, that would have been required in a financial statement to have the required statutory information about that donor. There are other donations where the individual donors would not be in the public filing, but the total donations would be listed. And of course, there would be a requirement to provide some details about how that money was spent, which we don't have. Now, I am aware that the candidate is here and has submitted a couple of emails with respect to what happened. In my view, frankly, to the members of the committee, those emails actually raise greater concerns, in my view, of violations of the Municipal Elections Act. Mr. Parker advises he did not file my audit, asked to extend my file. All he had was donations through a GoFundMe. And he also wishes to say I ran the campaign on a deficit. And some of the names of the GoFundMe chose to make their name anonymously. Now, why this is particularly, so first I'll say there is a process in the Municipal Elections Act to seek an extension where it's necessary to file. Although the act does provide plenty of time, and in this case, an auditor's report is not required, but the candidate would have had from after the election all the way until the end of December to complete the campaign period, and then all the way until the end of March to file the return, and then another 30 days into April to file it late. So you're looking at from the end of the election, about 6 months to get that form together, which is not a particularly complicated form. I realize if you do need to seek an extension, going to the Superior Court of Justice is complicated, but there was a 30-day period after the deadline where it could have been submitted by just paying that $500 fee. What's frankly more concerning to me, and that in my submission should be more concerning to the committee, is the candidate says he ran the campaign on a deficit, so presumably there was no funds turned over to the clerk, and some of the names on the GoFundMe chose to make their name anonymously. Now, it was my assumption when I filed this application that when a donor makes an anonymous contribution, that it just hides it from the public-facing website, but that the candidate still has access to the mandatory information. And what this seems to indicate is that these contributions were anonymous not only to the public, but in fact to Mr. Parker himself, which raises further issues of non-violation. And what I will point out is under the Municipal Elections Act, if you'll give me a moment, I'll pull the exact section. .8 subsection 8 For any contribution exceeding $25, it shall not be contributed in the form of cash and shall be contributed in a manner that associates the contributor's name and account with the payment or by a money order signed by the contributor. So that means any donations over $25, you can have like a pass the hat for under $25 and receive anonymous contributions that way. But anything over $25, the candidate needs to receive the donation with the name and address of the contributor, and then issue a receipt for that contributor. Now, sometimes you do receive illegal donations, and there is, in fact, a provision for that. Section 88.22 of the Act, which details the obligations of candidates, says expressly on paragraph O, a contribution of money made or received in contravention of this Act or a bylaw passed under this Act is returned to the contributor as soon as possible after the candidate becomes aware of the contravention. P, a contribution not returned to the contributor under clause O is paid to the clerk with whom the candidate's nomination was filed. And Q, an anonymous contribution is paid to the clerk with whom the candidate's nomination was filed. And so the issue here is it appears Mr. Parker received anonymous donations, which are illegal donations, and rather than paying that money over to the clerk, that money was used to fund campaign expenses, and then in total there was a deficit. So there was no surplus that could then be paid to the clerk, which means in effect, Mr. Parker was able to avoid funding his own campaign to cover those expenses by relying on illegal contributions that needed to be paid to the clerk, and has therefore received a financial benefit, in essence, from violating the Municipal Elections Act. So given these circumstances, in my submission, I mean, A, there's a clear violation of the Act, just from the failure to file, never mind the evidence and the admission that there appear to have been illegal contributions. But B, in my submission, this would not be an appropriate situation to A, not have a compliance auditor take a look at exactly how much was raised, where it was spent, where the money came from. But additionally, this is a situation where, frankly, a prosecution may be appropriate, because if a candidate can receive a financial benefit from violating the Municipal Elections Act without undergoing any kind of enforcement action that would include potentially a fine equivalent to the contribution that should have been paid to the city, so that money still ends up going to the city instead of enriching the candidate. And I realize we're only talking maybe a few $100s of anonymous contributions, but it's an important principle. My submission, the committee is failing to ensure that there is a proper deterrent for violating the Municipal Elections Act in a way that enriches a candidate and deprives the city of over contributions that need to be paid to the city. Now, if over the course of that compliance audit, more information is provided, and perhaps at that point, Mr. Parker pays the illegal contributions over to the city over the course of the compliance audit, as he was required to do and remains required to do, then it may be at that point, once the compliance audit was received, it may be appropriate to take no further action. But at this point in time, we have evidence that a return was not filed, evidence that contributions were received by the candidate, evidence that one of those contributions was over $100, and the public does not have access to information about that contributor, and information that the candidate received anonymous contributions and has not provided those contributions to the city clerk. And in my submission, given all those circumstances, this is an appropriate situation for the committee to exercise its discretion to order a compliance audit to receive full information about this campaign, and then down the road decide whether enforcement action should be taken. Subject to any questions, Madam Chair, those are my submissions.
Thank you, Mr. Weiner. Do any members of the committee have questions for the applicant?
I have a question to Mr. Weiner. There are other candidates who have not filed their financial statements, and probably they did not collect money through GoFundMe or any online tools. What about them? Why only this candidate?
It's not only this candidate. I point out I have next week another 4 applications, 3 of which are against other candidates. And again, I mean, as this committee has already determined, there's certain sort of more de minimis violations where it's decided not to proceed with compliance audits. So if there was no evidence the candidate actually incurred expense or raised revenues, like yes, there was a violation of the act by failing to file a financial statement. I don't know in those circumstances that a compliance audit would be warranted in all of those cases because there's no evidence that they raised or spent any money. I mean, at the end of the day, I certainly could have provided another dozen applications to this committee. I don't know if I would have been happy to receive that. I just had to pick and choose some ones to provide. And I think it's self-evident that a candidate who failed to file a financial statement when they did raise money and they did spend money has committed a more severe violation than one who failed to file a financial statement when they didn't raise money and didn't spend money, because there's more information that the public is deprived of about how that candidate conducted their campaign, because it's a more severe violation, and in that case, it may warrant a more severe penalty than the automatic penalty of just being barred from office. And we see that here. Even before we had a compliance audit, we have information that there were anonymous contributions that in fact there should have been money that should have been paid over to the city that hasn't been paid over to the city. So in a circumstance like that, in my submission, it's a more, I mean, again, I don't know if a few $100 is like an extraordinarily severe situation, but in my submission, it's still a situation that warrants some enforcement, and still a situation that is more severe than just putting your name on the ballot, not doing anything else, and just forgetting to file your statement.
Thank you.
Are there any other questions for the applicant?
Madam Chair, I don't have a question, but I do have a comment, and this just an observation of Mr. Wiener's comment that around the expectation that the compliance committee provides a deterrence to these type of issues, misfilings, and so on. I just want to clarify that it is actually not the objective of the compliance committee to be a deterrence. Yes, in cases where there are clear deviations from the standards and the legislation, we are to investigate it or make a decision on that. But deterrence, from what I believe, is not one of the mandates here.
Thank you. Okay, well, we now have an opportunity to hear from the candidate. I understand that Vivian Parker is available. And if so, do you wish to come forward and begin your presentation? Okay, perhaps I'm mistaken. Is Vivian Parker on this on this session? Yes. Okay. Okay. Could you please turn on your camera and unmute yourself? Okay, if you could give us a moment, we're just going to make sure that technology is working as it should be. Okay, we're just confirming that there are no technical obstacles. If you could indulge us for a few moments, please. Thank you. All right, the advice that we have from City Legal is that we're going to hold this one down to give the candidate an opportunity to resolve any technical issues that may be faced. We're going to move to the next item, and then we will come back to this again. Do committee members consent to that? And the applicant as well? Yeah, okay. Okay, so with that, then we're now going to proceed to the next item, the last item, which is EA 2.5, the compliance audit application by Kevin Weiner for election campaign finances of Keisha Ross. Are there any requests from the parties at this time? Okay. Hearing none, we're going to proceed. The applicant and the candidate will be given the opportunity to speak. They'll each be given sufficient time to address the application. Please confine your remarks to the compliance audit application before us at this time. Mr. Weiner, do you wish to come forward with item EA 2.5, please?
Yes. Thank you, Madam Chair. I'll just get one moment. So members of the committee, I'm not going to say much. This is, I mean, given the decisions already made today, I expect that this application is not going to be granted. There's the same reasonable grounds to believe that expenses weren't incurred without coming through a bank account as required by the Municipal Elections Act. And therefore, given there is at minimum an in-kind or actual contribution from the candidate, that the financial statement is not correct. This is the smallest amount of the applications that raise these issues. So I'll just repeat the submissions I made previously and allow the committee to make its decision. I would just note in general, however, with respect to the question of deterrence, that in my submission, deterrence is an appropriate factor for the committee to take into consideration. The whole point of this process is to eventually lead to a decision on whether or not to seek a prosecution for a violation of the Municipal Elections Act. The only reason regulatory offenses exist is specific and general deterrence to ensure that people comply with the law, because if they don't, that there are penalties for not doing so. Unlike in criminal proceedings where there's other factors like rehabilitation and denunciation, for regulatory offenses, the courts have generally opined that the point of those offenses is to ensure compliance with the law, whether the committee wants to call it deterrence or simply ensuring that there is a process for there to be consequences for a failure to comply with the law so that there is an incentive to comply with the law. At the end of the day, it amounts to the same thing. In my submission, it is one of the roles of this committee to ensure that in appropriate cases that there are consequences for a failure to comply with the law. Whether these particular instances meet that threshold, I leave to the committee.
Thank you very much for your submissions. Do we have the candidate here?
Yes.
Excellent. All right, so I have been advised by city staff that Keisha Ross is not here and did not attempt to connect. So with that, I'm going to ask for a motion to have the Compliance Audit Committee move into closed sessions unless members have any questions of the applicant? No, okay. So I will make a motion that we move and would ask you to raise your hand if you're in favor. Thank you. The motion carries. At this time, I will ask the clerk to temporarily close the meeting to members of the public and to only provide access to members and appropriate staff for the closed session portion of this meeting. In addition, the YouTube live stream will be suspended until the closed session is over. Members, I would also remind you to arrange your surroundings so that no other person observes any part of the closed session debate.
Thank you, Madam Chair. Hello, everyone. This is the committee administrator from the City Clerk's office. I'm going to read a statement for those that are connected remotely via WebEx. The committee is now going to move into closed session. We will first suspend the live portion of the WebEx live stream. We will then place anyone that is not needed for the closed session into a video conference waiting room. You will not be able to see or hear the video conference until the committee resumes an open session. Please do not disconnect or leave the WebEx meeting. You will be automatically readmitted to the video conference once the committee resumes in open session. If you become disconnected from the WebEx meeting while in the waiting room, please reconnect using the same meeting connection details that were provided to you earlier, or you can email the City Clerk's office at complianceaudit@toronto.ca, and we will work with you to reestablish your connection. The WebEx recording has been suspended. We are now moving individuals into the waiting room. And just a reminder to anyone in the committee room at City Hall who is not needed for the closed session to please exit the room. Members, please do not begin any discussion until we advise you. Thank you.
Thank you, everybody. We are now back in the public session. The committee has completed our closed session deliberations, and we will now post or put up on the screen the motion. I will make the motion, and it is that the Compliance Audit Committee rejects the application for a compliance audit of the election campaign finances of Keisha Ross. The full decision it follows, and it will be posted very shortly on the public site. Do any members wish to add any comments? No. All right. In that case, if we might have a vote, if you vote in favor of the motion, please raise your hand. Thank you. The motion carries. All right. So we are now moving back to item EA 2.4, and I understand that the candidate is available and wishes to make some remarks. So Vivian Parker, if you or your agent are here, if you would please begin your presentation.
Yeah, good day. I'm in an area I can't put on my video, but I hope the committee don't mind me being
without
video. Hello.
Yes,
Hello?
please proceed.
You okay without video? If that's
Yes, that's fine.
okay. I just want to thank Mr. Weiner for calling my attention to this, and I just also want to thank the community for giving me the opportunity to speak here at this moment and giving me the chance to explain myself in this situation. At the time when I was running for during the election, I was raising funds at the same time, but I couldn't do it because I had put in my name in the election, so I couldn't afford contracting. I had personal issues going on, which involved my family and death in the family, and all that thing that personally, like.
Sorry, I'm going to interject. We're having a really hard time hearing you. You are cutting in and out a little bit. Are you moving? Oh, that's a little bit better. Thank you.
Okay, so where did you hear last, if I may ask?
The last that I heard was that you had personal issues and then you cut out.
Yes, I had personal issues that was happening, which involved death in the family, like my mom and a couple of other family members. So I'm not explaining the fact that funds were used for that. I'm explaining the fact that it got too busy for me to put things together, and grieving after the time just drove, like, it wasn't negligence, it was just out of mind at that moment, and I still send an email to request an extension, and I tried to submit whatever donation I had, which was through the GoFundMe. That was the only donations that I had through the GoFundMe account. So I'm just, yeah, I was just in a position where I couldn't make any decision at the moment, and even find an expert to do my financing. So yeah, that is my only explanation to it. There's nothing else out of that, and I do accept the responsibility of not doing it, and I take on full responsibility for it. But I'm just explaining the situation at the time and what I could do at that time and I couldn't do.
Okay, thank you, Mr. Parker, and we appreciate you being able to connect and to provide a little bit of background. I have two questions, and then I'll provide an opportunity for my colleagues on the committee to weigh in as well. So you indicated that you had family sort of events that precluded you from focusing on things. Did you complete the campaign, or did you withdraw from the campaign before the election?
No, it was towards the end of the election that I had family happened, right? Like, which was, I had a death in the family that happened. So at that time, while the results was called and all that, and I was trying to work towards getting my finals together, I had that issue that was immediate that I had to take care of.
Okay, thank you. And my second question, you noted that you tried to submit the funds. So when you say that, are you suggesting that you tried to submit the funds to the city clerk?
No, not submit the funds. I submitted documents of a GoFundMe account that I raised fund through.
I understand.
Yeah.
Okay, and sorry, I said I had two questions, but I'm going to throw in a third one. So what did you use the funds for? The funds that were raised, I think it was approximately $1,200. What were they used for?
Yeah. The funds were used for what is it called? The printout for my card for my placards and whatever what is it called? The brochures for the election to hand out to people. That was what I actually really went in a more reasonable way to print some things out, because I had a friend of mine that was doing it for me. So I worked with him by working out some details where he helped me out print some placards, some brochures that I can hand out. That was what the funds were used for, nothing else. And it wasn't even enough for me to spend on that.
Okay, thank you. Do any committee members have any questions for Mr. Parker?
No, I don't have.
Sorry, no questions from the committee? No, okay, thank you. All right, well, I guess with that, we are going to move into closed session. So I'm going to make a motion to move into closed session. Can you raise your hand if you're in favor of the motion? Thank you. The motion carries. I will ask the clerk to temporarily close the meeting to members of the public and to only provide access to members and appropriate staff for the closed session portion of this meeting. In addition, the YouTube live stream will be suspended until the closed session is over. Members, I'd also remind you to arrange your surroundings so that no other person observes any part of the closed session debate.
Thank you, Madam Chair. Hello, everyone. This is the committee administrator from the City Clerk's office. I am going to read a statement for those that are connected remotely via WebEx. The committee is now going to move into closed session, and we will first suspend the live portion of the WebEx live stream. We will then place anyone that is not needed for the closed session into a video conference waiting room. You will not be able to see or hear the video conference until the committee resumes in open session. Please do not disconnect or leave the WebEx meeting. You will be automatically readmitted to the video conference once the committee resumes in open session. If you become disconnected from the WebEx meeting while in the waiting room, please reconnect using the same meeting connection details that were provided to you earlier, or you can email the City Clerk's office at complianceaudit@toronto.ca, and we will work with you to reestablish your connection. The WebEx recording has been suspended. We are now moving individuals into the waiting room. And just a reminder to anyone in the committee room at City Hall who is not needed for the closed session to please exit the room. Members, please do not begin any discussion until we advise you. Thank you. You want to ask before, just before, I think.
All right, thank you, everybody, for your patience. We are back in session. We have completed our closed session deliberations. We do have a motion, if I could ask that that be shared on the screen, please, and I will move it. We are moving that the Compliance Audit Committee reject the application for a compliance audit of the election campaign finances of Vivian Parker. The full decision will be on the screen for a moment or two, and it will be available online within a few minutes. I'd like to thank both the applicant and the candidate for your submissions and for your comments. Now, I will need the members to vote. So can we, yeah, all right, thank you. And apologize, sorry. All right, the motion carries.
Thank you, ma'am.
You are welcome. So this concludes our business for today. Before we actually finish, I just wanted to thank Mr. Weiner for your efforts and your contributions. The accountability process for election campaign finances can only exist with the engagement of individuals like yourself, and the committee is grateful to you, and we'd just like to thank you.
Thank you, Mr. Weiner.
And with that, we are concluded, so thank you, everybody. We are adjourned.